In 2011, the Lagos State government passed into law the Tenancy Law, the Administration of Criminal Justice Law. In 2012, it also passed the Lagos Traffic Law. Now, about 3 years later, how effective have these laws been? How did people respond to these laws? And have they been effectively implemented? That's our focus for this week's edition of Law Weekly. Welcome to the program. I'm Victoria Ido. First, let's take a look at some legal stories.
The House of Representatives is set to appeal the judgment of an Abuja Federal High Court, which prevented it from summoning the Minister of Petroleum Resources, Mrs. Diezani Alison Madueke.
There is corruption in most other places in the world.
The presiding judge, Justice Ahmed Mohammed, has also halted the House's probe of the 10 billion naira the minister reportedly spent on maintaining a private jet for her trips. The judge holds that the summons of the House to the minister to answer questions on the jet is invalid on the grounds that the House resolution was neither published in the Journal of the National Assembly nor in the official gazette of the federal government. The coroner's inquest continues with the National Emergency Management Agency, NEMA, and the Lagos State Emergency Management Agency, LASEMA, giving their testimonies before the magistrate. The witness, Fola Shoeton, the National Executive Coordinator of Lifesavers Foundation, LSF, said NEMA and LASEMA are not equipped to manage disaster in the country. In her testimony, she urged the federal government and the Lagos State government to ensure that adequate equipment are provided for the agencies in order to effectively contain emergencies. Meanwhile, the Chief Security Officer, Sunday Okoji, who submitted the unedited closed-circuit television CCTV footages of the incident from September the 12th to September the 16th, 2014 to the court, argued that the recordings contradicted their claims. Mr. Okoji said that both agencies arrived at the church about an hour after the building collapsed and gained access to the scene in less than a minute. Mr. Okoji further told the court that NEMA and LASEMA officials left the church at about 5:45 p.m. when several persons were still trapped. The magistrate adjourned the inquest till January the 6th, 2015, with the continuation of the CSO's testimony while rescheduling the testimony of the Ministry of Works for January the 7th.
With a view to enhancing better respect for the right of citizens by the police in the law enforcement process, as well as ensuring speedier dispensation of criminal justice, Lagos State passed the new Administration of Criminal Justice Law in 2011. Also in 2011, the Lagos State Tenancy Law was passed, asserting that the responsibility now falls on all property owners to make life more bearable for those who rent their properties. Described as a law to provide for road traffic administration and make provisions for the road traffic and vehicle inspection in Lagos State and other connected purposes, the Lagos Traffic Law was received with a bag of sentiment when it was passed in 2012. Lagos is home to over 21 million people, with additional people trooping into the city on a daily basis. Housing, traffic and administration of justice remains some of the major challenges faced in Lagos. Some laws were enacted to put a stop to lawlessness in these areas. The Lagos Tenancy Law, the Administration of Criminal Justice Law, the Lagos Traffic Law, which was signed in 2011 and 2012 by Governor Babatunde Fashola. The Lagos Tenancy Law applies to all premises within Lagos State, including business and residential premises. In Section 4, subsection 3 of the law, it shall be unlawful for a landlord or his agent to demand or receive rent in excess of 1 year in respect of any premises outside the exempted areas, as this will constitute an offence for which anyone found guilty will be liable to a fine over 100,000 naira or 3 months imprisonment.
Some landlord, when you want to rent a house, they will tell you a year, or some will tell you a year 6 months. when you now tell them about the Fashola tenancy law, they will tell you to go to Fashola house and rent the house. That they are not. This is not Fashola's house. So in such thing, what do? You have no option because the government so-called houses is the rich ones that are getting it. So I think the best way is you'll be subdued. Let me put it that way. You will do what they ask you to do. You pay a year or a year 6 months.
The law has been taking place, but it has not been effective and efficient in Lagos State. Only few places that has been taking place.
Another law passed in 2012 is the Lagos State Traffic Law, which was greeted with headlines like "Eat Gala while driving and go to jail." The law prohibits motorcycles and tricycles on 11 highways, 41 bridges and 696 roads within the state. It also regulates the conduct of drivers while driving. 2 years after, what's the effect of the law?
You see, the law is about that saving the lives of the Nigerians. You know, especially the express, taking people from here with a bike to island, you know, it's of a risk.
That traffic law is okay. The reason is that, you know, we can control this Nigeria through iron hand. And then upon that traffic law itself, people are still committing that offense, facing one way, park for unnecessary area. But what makes this law not work well is people that are monitored that law.
Lagos State also passed the new Administration of Criminal Justice in 2011, which is intended to repeal and replace the old Criminal Procedural Law of Lagos State 2004. This law is to enhance better respect for the right of citizens by the police, as well as ensure speedier dispensation of criminal justice. We spoke to the man behind these laws in a bid to find out what the law was made to achieve. The governor of Lagos State, Mr. Babatunde Fashola, he tells us that the Lagos traffic law is meant to assist residents and business owners in Lagos State spend less time traveling on roads and reduce the wastage of manpower in traffic gridlock, and thereby ensuring that the businesses and the economy of the state enjoys a rapid growth through easy movement. Saya, welcome to the program.
It's good to be here.
We just want to talk about some of the laws that were enacted and some amended in your administration. First of all, let's look at the Lagos State Administration of Criminal Justice Law of 2011. I know that the law was amended to repeal and replace the Criminal Procedural Law of Lagos of 2004. But what exactly was wrong with the Criminal Procedural Law?
Law reform is something that every society should have in a functional and efficient way. And if law reform work is not done regularly, then you would have laws that fall behind development. And some of the examples you would have seen was that in the Commonwealth, we are one of the most recent as a country to begin to amend our evidence law to admit electronic evidence when electronics had taken over our lives for well over 2.5 to 3 decades. Many jurisdictions had done that. So law reform is the way to make those periodic amendments. That didn't happen with regard to the criminal justice system for a while. So many of the laws and rules that were applicable were those we inherited from the colonial administration. So you had laws that are 85, 90 years old when so many things have changed. So that was essentially to bring them into contemporaneity. The people who gave us those laws have changed and amended and reviewed their laws many times. So one of the things I've done lately was to reinvigorate the Lagos Law Reform Commission. Even in the last few years, some of the laws we've passed, we've had cause to amend. And so for citizens to know what the law is, you must continuously harmonize amendments and put them into one form.
Now, what were the major changes effected in the law?
Well, there are a lot of top-line changes that were made in the way cases are presented. In some places, we had to review provisions that were made when, if I recall correctly now, it's 3 years since I read that legislation. Some of the things, the penalties were no longer consistent with what we were doing here. Then it introduced, for example, community service, which was not part of the administration of justice system. There were things that people were doing that we didn't think that custodial sentencing was the way to go and just put people in prison, maybe for sanitation offenses, but if they serve community sentences. So you needed to invest the sentencing authority with legislative power to say, instead of going to pay a fine and go to prison, actually go and do community service, compulsory community service, and so on and so forth.
Now, recently, there was a survey by Access to Justice, and they said that the major goals that this law was supposed to achieve was not achieved. What is the reason for that setback?
Well, you see, first of all, I haven't had the privilege of reading the report that you have referred to. That's the first thing. And I think a conclusion that is so generic in terms is not something I can address. But the important thing I would like to say is that it is first a credit that goals were set. So we were not drifting. And the reputation of this state and this government is to set very ambitious and high goals. Whether we meet them immediately or in the medium or the long term is really a matter now of debate and the resources that we have to work with. And when you compare us with any benchmark, you must try to compare us with cities and states that have the kind of number. So if you are comparing us with states or cities that have 3 million people when we're 21 million people, you are certainly comparing apples and oranges. So, but it's important there's a goal, there's an aspiration. In the race to excellence, one of the famous and very appealing quotes I've found, which dimensions how human beings must set their affairs, is that in the race to excellence, as a state of excellence, there can be no finish line. So it remains continuously an aspirational objective to be the best. And when we meet what were our goals yesterday, we will not stop. The next thing is to set newer and much more ambitious goals for excellence. So, but if I see those reports, then it will be easier to address the micro issues that they are raised. But in terms of administration of justice, for example, many of us have watched the Oscar Pistorius trial in South Africa. It took about 2 years. That's around the same time it takes to conclude a criminal trial in many parts of the world. And that's how long it took to conclude some of the trials we've done here.
Let me ask this. Is that something that really can be done as regards to lawyers that, you know, bring up applications just majorly to stall proceedings in court?
Well, you can bring up some of the challenges of defining access to justice is that there are limitations about some of the things that can be brought on. There's always a danger in trying to circumscribe those applications, how really not to do injustice while trying to do good. There's always that danger. There's an old case, Elias and Disu. Again, it was a simple application, but testing the very foundations of evidential practice and procedure, where a plaintiff calls the defendant as his witness, and the defendant says, no, you can't call my witness. You can't call my client as witness. And there was a full-blown argument bordering on competence and compellability of a witness. And it was a matter that had to reach the Supreme Court in those days before it could be resolved. So, but we've argued here back and forth that, look, listen, are there issues where appeals should be limited to final decisions only? Or should they be limited to, should we permit interlocutory appeals to go subject to leave of court? Those are some of the things we've put in place. I follow the Pistorius trial again. Counsel has sought leave to appeal. Leave has been given, I think, limitedly on some matters. Leave has been reduced on some matters. In Nigeria, once it's a final decision on sentencing and verdict, you can appeal both. In some jurisdictions in Europe, there are places where interlocutory appeals, you will not go beyond the Court of Appeal. But ultimately, it's the skill of counsel to know that there are matters that they can ventilate at the appellate court without necessarily delaying trial.